Hi everyone, thank you for joining today's webinar. We'll just wait 30 seconds or so just for everyone to join us. We'll just wait a little bit longer. Okay, right, so good afternoon and good morning to all of those of you that have joined from abroad. My name is Melanie Pitsey and I'm the CEO of the Global Payroll Association. So thank you for joining us for today's webinar. The last time I met Danny was the week before lockdown, and I think we both knew that it may be the last day for a while that we'd all meet up again. And Danny presented at the GPA UK Summit a session on holiday pay, which was very well received. Since then, we've had a number of requests for Danny to run a further session on this and to update us on what the latest situation is. So welcome, Danny. Okay, so before we start, let's go over a few housekeeping. Danny, if you could just move the slides, thank you. Okay, so we are live streaming and recording today. Danny has said that he will be more than happy to answer questions. I have a feeling we might have quite a lot of questions and there's a lot of content to get through. So there may be some questions answered post-event. We also have our app, GPA Network app. It's available on Apple and Android. So if you do have any questions, please feel free to ask any of the questions on there, and obviously it's the payroll community, so hopefully that will help everyone that has got an issue or wants to learn more about holiday pay. We do want to keep this quite interactive, so please feel free to ask questions. We've also got some polls throughout the session, and I hope you do get involved. So I think that's enough of me, and over to you, Danny.
Thanks a lot. Yeah. Welcome everybody. I'm Danny Rice. I work for Workday and I head up the UK payroll product management team there. As Mel mentioned, I've been out and done a previous webinar with the GPA, and I've also attended the summit as well. Both times were around holiday pay. So there may be, in terms of people who've previously seen that, I apologise if there is content you've seen before. What we're trying to do is balance it for perhaps people who've attended the webinar, perhaps people who've attended the summit, and those who've never been and never seen any of these sessions. So there is something in there for all. There will be some level setting in terms of the requirements around holiday pay, but as much as possible, I'm trying to include new content as well, which will hopefully be of interest. So in terms of the agenda, we're going to do a holiday pay background, the guidance overview, what the guidance isn't telling us directly, some approach and options, and final thoughts there, and then hopefully we'll get to quite Q&A. As Mel said, there's quite a lot to get through today, but I'll try and hammer through as quick as I can. And definitely please ask those questions. We absolutely love them, and it makes the session far more enjoyable for us. So in terms of holiday pay background, so back in July 2017, the government report, which was Good Work, the Taylor Review of Modern Working Practices, was published. And this, one of the things it's locked in on was around holiday pay, in that there was no real direct sort of guidance around this. And again, this may be saying what people have experienced in their own sort of companies, where generally it was around kind of 12 weeks people were doing. There was no hard, fast rules, legislation around it. So it was very much open to interpretation. And one of the first things the government did was suggest that this look back period, which is going on currently 12 weeks, needed to go to 52 weeks in order to average out over a year and again prevent any practices where workers might be stopped from taking holiday because they had a rather large commission or overtime payment in those 12 weeks. However, they wanted to take it further as well, and they're saying basically to find 52 weeks, you have to go back up to potentially 104 weeks. And we'll talk about that in a bit more details in a bit. Then BEIS, the Business Energy Industry Strategy Department, they came along and they said, yeah, there's no guidance here. We want to get some guidance out there for this. Back in February 2019, they first issued calculating holiday pay for workers without fixed hours or pay. And at the time, they reached out to a number of payroll vendors and various other interested parties. and try and gather as much information about the various challenges of running holiday pay without, no real rules or anything. Unfortunately, their legal advisor had pretty much the final say on what went forward. So as you'll see as we go through this, and maybe you've seen already, in terms of the way the guidance work, it leans more towards employment law than what you may deem perhaps standard payroll practices. Moving on, so in April 2020, when the legislation, the 52 weeks out of 104 weeks, that is legislation, came into place, BEIS issued their latest guidance as well, which, what we're going to dig into today. And since then, on the 23rd of July, they've actually issued some revisions to it, only minor tweaks, nothing too major. So this guidance states how holiday pay enhancement must be calculated and clearly states it's unacceptable to apply rolled up calculations. So this might be where, for example, you're adding in a little bit extra onto the normal hourly rate to try and accommodate any holiday pay payments the worker might or might not get. So there is a big change there, and again, in my own experience, I've seen a lot of organisations take that approach. So the guidance overview, so the government legislation on changes to holiday pay took effect on the 6th of April 2020. That was the 52 weeks. The legislation covers the governance of the reference period. This is the length of time used to gather a worker's earnings to determine the average holiday payment. BEIS have issued their guidance, as I mentioned. There's a link there to it. If you haven't seen it, I really recommend you go and read it if you haven't. And the point here is this is guidance. It's not legislation. However, this is very much the measurement they will use if you were to be assessed on, are you paying holiday pay correctly? And again, it's what ACAS uses as well. Disclaimer at the bottom there, and you'll see this a few more times, I'm not an employment or legal expert, so you need to seek the correct legal guidance in making the right decisions for your organisation. All I'm doing is giving you an overview of what that guidance is, and obviously trying to open it up and point at the areas where you need to perhaps focus mostly. Before I talk about the reference period, again, just another item is this is very much focused on the holiday pay element, not around so much holiday pay entitlement rules and that kind of piece of it. It's very much the payment part. So the reference period is a length of time used to gather a worker's earnings over to determine the average holiday payment. So the holiday pay average calculation is based on 52 paid weeks. These weeks qualify if they have remuneration in them. So even if the worker earns £10, they've worked that and got that £10, that week qualifies. However, if there's no remuneration, that week should be ignored. Because of that, you must go back potentially up to 104 weeks to find 52 good weeks, 52 qualifying weeks. So maybe you start your count back, you've gone back 20 weeks, and then you find a block of 30 weeks because perhaps the worker's been out on a long unpaid absence. Then you would discount those 30 weeks and continue your look back around week 51 and carry on marching back. 104 is the maximum amount of time you should go back. If you only find 1 week in that period, you only find 1 week, but you have to look for 52 good weeks. For workers who have earned less than 52 weeks, use all available qualifying weeks. So if they've hired 10 weeks ago, 20 weeks ago, we use what's available. For workers under TUPE, where continuous service applies, so if they've moved from between organisations and they've kept obviously all their employment rights, then you must use the reference period history into the previous employment, again, up to those 104 weeks. If a worker takes leave before completing the week's work, a fair representation must be paid. They don't give exact guidance around that, but you must have a look at what they're earning and what they, based on what you would expect them to earn in the week, and use that as your guide. Moving on, some quick examples here. So the normal reference period, as mentioned, is 52 weeks. I'm not going to try and squeeze 52 weeks onto a slide, but hopefully you'll get the idea of what's going on. So this worker's gone on holiday here, and we start our count back over these weeks, and bang, we land at week 52. As I mentioned, if there was a zero payment in the week, we would need to skip that week. So we see this blue line coming instead and saying, nope, exclude that, we go back to week 53. And just quickly there, the final scenario is if the worker is under 52 weeks history. This worker hired in week 24 there. They've also got a zero payment. However, it's going to make no difference because the max we can go back is 24 weeks anyway. Okay, so In terms of a week, BAYS provide a definition of that as well. It's linked to the Employment Rights Act back in '96. So a week is defined as starting on a Sunday, ending on a Saturday, very similar to SSP. The holiday pay reference period should start from the last whole week, ending on or before the first day of holiday. And for weekly based pay frequencies, you are allowed to use your week definition based on that schedule. So if you have a weekly payroll that starts, say, on a Monday, ends on a Sunday, you can use that. However, if it's monthly, you've got to use the format they're setting here, the Sunday through to the Saturday. And again, a very quick example here. We can see this worker going off on the Thursday. We're going to start our look back. We need to do it from the Saturday before for the first whole completed week. And that's when we start rolling back. These payments here wouldn't be included. These ones backwards would. So monthly workers. This is kind of like the big elephant in the room, really. So monthly is the most commonly used pay frequency in the UK at approximately 87%. The guidance attempts to break down the monthly workers into two distinct groups to try and tackle this. So where a worker is paid a regular monthly salary with fixed hours, fixed pay, there is no need to make a separate holiday pay calculation. The individual will be paid their normal monthly amount for months where holiday has been taken. And maybe that's like many of us on this call. You know, if we go on holiday, our company doesn't reduce our salary, it doesn't pay us under a separate holiday pay earning, it just basically we get our salary. However, for those individuals paid monthly, but where their pay varies, for example, depending on the amount of work done, so maybe they're doing regular overtime that qualifies or commission, this employee will need to use the holiday pay reference period. So we've got a bit of a challenge straight away. We have monthly workers and we're putting a weekly framework over the top of that. So why does the guidance propose a weekly reference period framework for monthly paid workers? There's three reasons BAYS present around this. So the guidance rules out using 12 months as a corresponding period to 52 weeks, the same basis comparing apples to oranges. You need to exclude, so you need to have to exclude the weeks which don't qualify with no qualifying earnings, so zero pay. Obviously, if you're wrapping everything up into 12 months, you can't see in those 12 months where there's been a zero payment week. The reference period starts from the last whole week, ending on or before the first day of holiday. So monthly look back is very much tied into payment dates. You know, rolling back from a week start, then you're not necessarily going to include information if you're pulling it from a payment date that hasn't happened yet. So the concept of weekly pay is used in legislation because it's always the same length of time. So therefore, the guidance lands firmly on evaluating earnings history on a weekly basis, regardless of the monthly pay frequency. See, this definitely creates some challenges. So an example below, we can see the worker's gone off on holiday on the 13th there, so this green block. And this has a number of impacts. So the first 2 weeks of the reference period occur in the current month. So this is perhaps going to happen on the 24th. This is when they're going to get paid next. However, we've got 2 weeks kicking in straight away in that month that haven't been processed. So again, when this payroll is run, we'd need to include the payments associated to these 2 weeks, but nothing for the subsequent weeks. In addition, we can see this second week here is actually split across 2 pay periods. So again, this would need to be respected as 1 week. And then also the contractual date, which is the 25th for payment, has no bearing on what's going on here. It simply doesn't matter. So the guidance doesn't provide explicit details on how to calculate the final payment rate, daily or hourly, but more around you converting monthly data into a standard format. So again, there's two approaches they propose around how to standardize payments for monthly workers. So firstly, we have without normal working hours, but a fixed rate. And what they say there is you should be able to calculate their weekly earnings by using your records of hours worked. So the assumption is you've got on your system lots of information about each week, the hours someone did, and the rates, sort of standard rate, may have changed with some pay rises, and that's what's been paid to this worker every week, and that should be easy to pull. Is their view? Not saying it is, but that's their view. Without normal working hours and a variable rate of pay is the second group. So it may be necessary to use an average hourly rate to estimate a worker's weekly rate. Then when use of an average hourly rate of pay is necessary, the weekly rate of pay can be calculated by multiplying the hours worked in a week by the average hourly rate of pay. And there's a formula they provide about this, and I've got a visual to make that a little bit more digestible. So What they're saying basically in this example, and this is taken from the guidance, is this worker's worked 130 hours and they got paid £1,250 in a month. This is the breakdown of the hours they worked each week. There's a part month at the end there, so you've got 15 hours creeping in and the rest into another week. What they're then proposing is you take that, divide it by 130, and then you get an hourly rate. Now, within this amount, there could be their basic, say £1,000, and there could be £250 of other earnings, overtime, commission, whatever, that comes in. Then they're taking this hourly rate and they're applying it across these different weeks to generate an average. And you do this for the duration and then average that to get your average week. It's interesting stuff. Another quick version of that example, just something I wanted to highlight again why the hours, the weeks matter in terms of what you've worked. So all I've done is I've put a 0 in week 2. That corresponds back here. Again, the rate is the same, but what you'll see is these rates get bumped up here because this week should be excluded. These are more higher paid weeks. Naturally, when you count back, potentially this worker would have a higher average maybe than this one here, where it's spread across those 4 weeks. There's another visual taken from the guidance. I'm not going to dwell too much on this. What I'm thinking is if people do have a lot of questions around the payment breakdown and how to tackle it, it might be something we can look at for a future session. Let us know. But I don't want to spend a lot of time drilling into calculations at this point. It's more breaking out the other parts of the guidance I'm looking to do today. But again, just an example. As I mentioned, this is in the guidance itself. So this worker's going on holiday here. We then start our look back process. These grey dates would be the normal payment dates, and we're counting weeks. And what they've done on the other side here again is given a cut down visual of that. So we can see for those different months, the total amount of pay, the hours, as I showed you a little while ago, and then the breakdown of that hourly rate. What they then do is take that hourly rate and they apply it on a week by week basis for the hours worked to generate that average over all those weeks. Okay. So moving on, calculating for irregular or 0 hours. So the same guidance rules apply for workers with irregular or 0 hour contracts. There's no separate approach you should be taking, no rolling up into hourly rates. This means that you must count back the 52 weeks up to 104 weeks if there are periods of no pay. A paid week would include a week in which the worker was paid any amount of work undertaken during that week. So again, as an example here taken from their guidance. And as you can see, this worker has some periods of 0 pay, but they've got a week here where they just earned £10. That counts. So in terms of the averaging, obviously that's going to drive that average down, be it it's over 52 weeks, so the impact may be minimal anyway. But again, if they earn, the week should be in. If they don't earn, the week should be out. So short or temporary contracts, the guidance applies also to workers on short or temporary contracts as well as agency workers. This means if a worker doesn't take all their holiday entitlement by the time they end their employment, you must pay the untaken holiday pay using the guidance provided as the same for any worker. So again, if you have a worker who's say on a 40-hour week, standard contract, and they leave, you'd have to pay them any untaken leave. That applies as well for short or temporary contracts. Any accrued holiday they haven't taken, you have to pay that to them, and you have to pay it based on the guidance. Again, no applying percentages or any kind of rolled up calculations. Since these workers are unlikely to have 52 weeks of earnings history, you must use your available weeks to form the reference period. So if they've got 1, 2, 5 or 10, that's what you would use to do that averaging. The guidance explicitly states it is not acceptable for an employer to add a rate on top of the worker's hourly rate to account for holiday pay. So again, rolled up. Moving on. So one of the areas which was very unclear up until April last year was the impact of things like absence, particularly previously paid holiday weeks and statutory absences, and how they would impact the reference period, because there are earnings, but however the worker hasn't necessarily worked. And this is something which personally myself, I was pushing BASE quite heavily on, and they have provided clarification around that to a degree as of what went out in April. So there are a number of sections within the guidance in regards how periods of absence should be dealt with. There's about 3 or 4 sections there in all. The first thing to remember is if there is no pay, then the week is excluded. If the worker has done some work, it should be included. So there's 3 main scenarios that need understanding. First is paid holiday. So over a period of 52 weeks, any worker should have taken some holiday. and based on that holiday, based on the guidance, they would have had some holiday pay enhancement probably paid on that. However, there is a question on if these weeks should count within the reference period. And the guidance, again, breaks these down into two sets of categories of workers. So the first set is with regular working hours but variable pay. 4 weeks of holiday should be excluded. For part weeks, only hours in which the worker they worked should be included. So if I've had 2 weeks off and I got paid holiday pay for it, as one of these workers, those 2 weeks should not be included in the count back. I would go back an additional 2 weeks. However, if I've taken a day or 3 days off, because that week has hours worked, the portion of where I worked should be included. Again, the holiday pay would not be included in the calculation. The second set is without regular working hours. So any week of pay should be included, including weeks where only holiday pay was received. So everything there is included. So if I go on holiday for 2 weeks, that would count in my count back as 2 weeks. Moving on, the second group here is unpaid leave. So if a worker has a period of leave, then any weeks with no pay should be excluded. So that should be pretty straightforward. Statutory payments. So where a worker has a week of statutory payments, this should be excluded as well. So if you're paying someone SSP, if you're paying them statutory maternity pay, they're not working, so those weeks should be out. Unfortunately, though, the guidance in regards to points 1 and 2 above, the guidance only focuses and provides examples on a full complete week, which isn't necessarily the most reassuring scenario to review, because obviously, people take part days or have part sickness naturally, and there is nothing explicitly called out about the part weeks. However, best way to look at this again is to go back and understand the original guidance we've already talked about. So if a week with remuneration, it qualifies, even if it's just £10. If I've gone off for perhaps 1 day's sickness, that week will count. However, the earnings associated to that sickness will not be included in my count back. Weeks with no remuneration should be ignored. So this suggests if a part worked week occurs in regards to points 2 or 3, if the worker has done some work, it should be included. And again, just a quick example here. So I mentioned there was 2 different categories there in terms of with regular hours and without regular hours. So this worker's going on holiday and the count back starts. In terms of the with regular hours, the first holiday group I talked about, they have holiday for this week free. This would be excluded, but in week 4, they've actually worked 3 days, so this week would be in. In regards to the without regular hours, the whole lot is included. There's no break because they've had holiday here. So pay for leavers. So for workers leaving employment, and we've touched on this already, who are owed holiday, this must be calculated using the guidance rules. This also includes if they're made redundant. If a worker is then rehired under a new contract or with a break of employment, their reference period cannot go past new hire date. So maybe they left and decided they didn't like their new job and came back 3 days. That would be the new start date would be their new reference period start as well. Exception there is for TUPE transfers where continuous employment exists. Their reference period would go back past that naturally, prior to that new hire date and into their prior history as well. So paid versus earned. Typically, many workers impacted by holiday pay guidance will be paid in arrears. Potentially they're claiming hours and entering it into a time tracking system, and that needs to be authorized and go into payroll. So due to this, there will be a delay, as I mentioned, in their timesheet being approved by the manager or just because payroll cuts off. And the guidance provides an example around this. We've got a worker who is paid normally on the 21st of each month. The payroll cutoff is day 15th of the month, and therefore on day 21 they are paid for the hours worked between the 1st to the 14th, and for any scheduled contractual hours for the remainder of the month. So they're sort of normal basic pay, if you like. Therefore, they are partially paid in arrears and partially in advance. In these cases, if the worker goes on holiday in the preceding month, with the rest of their pay is still processed when the rest of their pay, is processed, that pay will need to be included within the reference pay. So reference period, So they go off, say mid-August, and August combines some of August pay, but it also has a bit of July pay that wasn't processed. That July payment would need to be pulled back into the weeks it applies to in July. So the guidance states it may be acceptable for an employer to pay a worker for any additional holiday they are entitled to in the pay reference period that follows immediately afterwards, providing the worker is not thereby disincentivized from taking holiday. So again, I've got a visual on that. This is quite a big one to start with. We'll do a simpler one in a second. So what we got here is the month of April 2019. And what we can see is the week breakdown if we were to apply a week framework for the reference period. We've got the dates, the actual hours have been entered, and the effective date they were worked and the type of earning they were. So the workers clocking away, generally on the weekends here, they're doing a bit of overtime. And what we'll see around the 19th, 22nd there's some kind of payroll cut-off kicking in. And this particular overtime here wasn't authorised till the or entered at least to the 26th of April, missed our cut-off, so it's been pulled here into this big lump of green stuff, and that's all been processed in May. It all missed that cut-off around the 22nd, 23rd of April. And what we would see in April in a normal monthly payroll would be what's been processed in April in regards to blue, and then the rest being paid in May because of that cut-off. And as similar with April, there'd probably be a lump coming in from March as well. From a reference period point of view, these May payments should be aligned to their April weeks in which they occurred. As I said, it's based on when you actually did the work, when you earned that money, not on when it was paid to the employee. So a slightly cut down version of that. We've got a worker here who goes off on holiday and we start our account back. If we go all the way back to 52 weeks, what we may find in the 52nd week there is £50, but this £50 relates to week 53. So this would need to be excluded from our reference period. However, back at the start, we got £100 here being paid in the current month. However, that was in relation to week 1. So that would need to be pulled back in, and that's where we would need to include it. In the same way, we may have a similar scenario where perhaps the worker earned £0 in week 7, for whatever reason. Maybe there was a delay in signing the timesheet off. Because of that, that was paid to them in week 6. Now, this is probably a monthly payroll, and from a worker point of view, they would never have been sort of penalised for that. However, from what was entered and approved into the system, there may be a gap into it. So this would need to be considered in week 7. That's the effective date it's linked to. So this period, this week 7 here, shouldn't be excluded from our count back. There shouldn't be a reason to go further back. So what the guidance doesn't say. So relevant earnings, in regards to which earnings are included in the calculation of holiday pay, is very much open to interpretation. Ultimately, it boils down to how the payments are earned and thus how they are normally received. The main determining factors are, is it linked to the performance of the task which the employee is required to carry out under their contract of employment? It relates to the employee's professional personal status. It reflects the contractual results based on commission an employee ordinarily receives. What I've done is provided some suggestions here, but again, there's that disclaimer there, I'm not an employment expert. This is where you need to seek that additional legal advice, that guidance from people who can give you that clear understanding. What you'll find, and again, this will be a bit more of a recurring theme now as I continue this presentation, bays don't come down heavy on a number of areas. This is ultimately guidance, but it's the guidance they're going to measure you to. And what they'll say in certain areas is go off and obtain legal guidance, providing what you're doing appears to look above board, then ultimately you're probably going to be in a good place. So reference period versus calculation pay. So for many workers who might receive a fixed wage every pay period, so again, sort of touching back onto our monthly workers here, and then a variable amount of other hours based on payments, it's possible many organisations wouldn't pay these workers holiday as a separate payment. So again, I'm going on holiday for 2 weeks. In a monthly payroll, you may not stop my pay for 2 weeks and then pay it under a separate earning as holiday. You probably just pay me my monthly salary. So they wouldn't receive this reduction in salary, as I mentioned, and a separate payment. For such workers, holiday pay tends to be a supplement paid. And again, this is what I've seen with other customers I've worked with. You don't have to do it this way. You may want to stop and start paying all holiday pay under one earning. That's completely fine. I'm just calling this one out here. So In these instances, obviously, they're going to want an additional earning for this enhancement, if you like, for holiday pay. And if this is an approach you prefer to follow, then you need to assess each week still to determine if the worker was paid or not. So it creates a little bit of a challenge. What we got is, in terms of the reference period, we're looking at overtime and commission to work out that enhancement, but we're not looking at basic pay. However, we still need to assess basic pay to know if they were paid or not, because there may be some weeks where they earned nothing, or it might just be a week they got their basic pay, but they didn't get any overtime or other qualifying earnings for holiday pay. If this is something you're doing, just again, calling it out, what you would need to make sure is you still assess from a reference period both the basic pay and any overtime or enhancements to ensure that you are including the right weeks and you're not counting back extra weeks you don't need to. However, from a payment point of view, you're probably going to be just looking at this subset of overtime or whatever might be in that additional pot there to work out the actual payment itself. And again, the worker still gets their flat monthly salary as they would anyway. So holiday blocks. So again, more of just something which could catch people out. So if a worker who normally works Monday to Friday takes 2 weeks off, this should be considered one holiday block, not two separate blocks of holiday. So in this example here, the worker's gone out for Monday all the way through to Friday here. Our rollback would start on the Saturday before, and that's when we would start looking back. In this example, the worker's actually come back in on the Monday. So what we have is two separate look backs for these two separate absences. This first holiday block, we start on the Saturday here. However, because they've come back into work on the Monday, if they go off on a Tuesday, we would start our look back here. Now again, depending on the type of worker, we may or may not include this holiday in the look back here anyway, so it might be a bit of a moot point, but just calling that out there. Again, just show an extreme example of the way you may have to tackle calculations from a monthly point of view. And I've seen people do this. So somebody takes off every Friday in the month. Perhaps it's getting near the end of the leave year and they want to use their leave with a whole bunch of shortened weeks. In that instance, because you're rolling back from each of the individual Saturdays before, what you would have in May is 5 separate look back periods, each going back their individual 52 weeks and each with their own individual rates. Now, it may be that by the time you've been through all this and done the calculations, there's very little difference in these rates. Divide them over 52. However, that is what BAYS are basically proposing. And another funny little one here is where a worker perhaps goes on holiday for 2 weeks. However, this crosses over potentially 2 different months. So from a look back point of view, we would potentially start actually from here and we would start our rollback. And obviously when we get into August, from a look back point of view, because this is one holiday block that's joined up, we would still need to start from the original look back in July here. So we're not doing a separate one, this is one block of holiday. So there's no requirement to bring hours into the reference week where a worker has shifts crossing midnight. So again, it's one of the things we push BAYS on. What they basically say is there's no direct guidance on what you should do. So if a shift starts, for example, on the Saturday and carries on into the Sunday, you don't necessarily have to pull those hours from the Sunday into that Saturday week. What they say is use a standardized approach to all workers. Midnight makes sense, do that. If it makes more sense for you to do the when the shift itself earns, again, they're fine with that. You just have to use a very consistent approach for that. So units and commission-based payment. So again, the guidance doesn't provide much around this, and it very much assumes everybody's claiming hours. Everything's in a nice hours format. However, if you do have workers who work things like commission, so they're going to get a lump payment, and this is probably going to be linked to a period of time, maybe for a quarter or maybe for a month, or if they're doing sessional-based payments, so maybe they're doing a task, and for that task, they're going to get paid £200, but that task could relate to half a day's work or 2 hours. What you need to be very careful of is ensure that you have some kind of standardized information associated to that, so a number of hours. So if it's commission over a period of time, you may want to consider the normal working hours that person did in that period of time against that commission payment. If it's a sessional based payment, perhaps based on certain tasks, there's a number of hours you'd expect that worker to do. Reason why this is important, if you don't have that that standardization with them in terms of hours, you could potentially take somebody who's earned, I don't know, £10,000 commission and drop it into a calculation where there's no real associated units for that. And obviously what you're going to do is you're going to drive up that payment to that worker. And because that commission obviously hasn't got a series of units associated to it. And this can be quite costly because ultimately what you're going to do is you're going to pay the employee more because you're not in any way recognizing the period of time associated to those types of payments. Furlough workers, so there is some guidance around this now. This is straight from the government website. This does change, not so much at the moment, but certainly, as you probably all know, in the early days of COVID, it was changing very regularly. So it's always worth going back to check this. So what they're saying at the moment is workers who have been placed on furlough continue to accrue statutory holiday entitlements and any additional holiday provided for under their employment contract. An employer should not automatically pay a worker on holiday the rate of pay that they are receiving while on furlough. So unless the employer has agreed to not reduce the worker's pay while on furlough. So if a worker on furlough takes annual leave, an employer must calculate and pay the correct holiday pay in accordance with the current legislation. Where the calculated rate is above the pay the worker receives on furlough, the employer must pay the difference. However, as taken holiday does not break the furlough period, you can still claim back that 80% from the government. However, you're on the hook for the holiday pay enhancement there part. So quite a lot of information. I'm sorry, I'm motoring through. As I mentioned, there's a lot I want to share. And again, you know, it probably feels like information overload at the moment, and there may be some fear for some people about this is, you know, a lot here, a lot of complexity. You're certainly not alone. In this sort of final section here, what I want to do is talk through some approaches to where, in terms of what you can tackle to try and you know, where to start with this, and also some final thoughts as well in terms of where holiday pay currently is. So if you are currently doing nothing for holiday pay, then you are potentially in a very risky position. Now, if it doesn't apply to your company, great, that's good. However, if it does, you need to start looking at this. So the government is looking at a single labour market body to enforce minimum wage and holiday rights. In addition, the government is also starting to advertise worker rights on holiday pay. So even if you aren't meeting every part of the guidance, you're in a far better place than if you did nothing at all. So again, you open yourself to fines for non-compliance, being publicly named and shamed. And also there's potential for massive back pay claims from the employees as well. So there's been rumours and suggestions that the requirement for holiday might be dropped with Brexit. However, if you understand the history of holiday pay, it's come from UK legal cases. This is not something Europe's dropped on us. This is something which UK employees took to court and they won. So I don't believe this will be going anywhere anytime soon. So what we see with companies in terms of the approaches when starting to look at this, the kind of things they look at is, you know, how are our workers currently paid? Are they monthly? Are they weekly? Do we have 0 hours contracts? So getting an idea of what your population looks like. Review if they hold the worker details needed to ensure correct payment. Do we know their shifts? Do we know the dates the hours are worked in the system? Or is it all punched in so all of May just goes in as May? Review their earnings setup and confirm if they should or shouldn't be considered for holiday pay. So yeah, what earnings do we have? Getting that right guidance on whether they qualify for holiday pay or not. Whether payroll is broken up across different teams and locations, again, getting people together and making sure you're taking a consistent approach across the whole organisation. Confirm if the organisation's what the definition of a week is. You know, do you just have monthly, in which case you're very much in that Sunday to Saturday? If there's shift workers, can we start at midnight on Saturday for all workers? So it's very much about getting that initial stake in the ground about what we're going to standardise here. Work through any corner case scenarios to flush out possible exceptions. So again, looking at things like commission, if you put that through the calculation, what's that going to do? And again, just understanding where the outliers are and what you need to put in place to handle those types of workers. Moving on, we see companies apply various approaches in reviewing current payroll systems and also feeding systems. So does the payroll system have access to the data it needs at the point of calculation? Does the payroll cover the latest holiday pay guidance? If not, what is it capable of? So have that discussion with your vendor, sit down, what can you offer us currently in terms of holiday pay? And it may be that they can do more for you, but if things like overtime is all entered as a monthly amount, and obviously from a vendor point of view, there's going to be very little they can do about that because they're not going to know what weeks that applies to. If configuration is needed, can the vendor support this? Can they, and also they validate, or what you should do, sorry, is look to validate what that vendor solution does in terms of your expectations as well. If the vendor is unable to support anything around holiday pay, try and understand what they might be able to do. The thing to remember is this is not just about payments. Companies need to be able to group holiday blocks together to determine paid weeks. So, you don't just focus in on the payment side, also look at those feeding systems, particularly around the way holiday comes in, and also what you hold from a shift point of view for these workers as well. Understand how this data is needed currently. The data that is needed, sorry, is currently held on your system. So again, do you have 104 weeks? Can you determine non-paid weeks? Can payments be associated to the weeks they're paid? If they're in the process or likely to be undertaking SHUPI process of new payrolls into the business, then again, you need to think about those 2 years worth of history. Can your system hold that? Do you need to hold it in some third-party application? Now this, again, just an approach. Anything like this, you need to seek that clarification. So what I certainly did when I started looking at the guidance when it came in, and this is what I'd recommend anybody to do, certainly if they're unsure, is I took a number of scenarios where I took a worker who had earned 12 months of salary based on a monthly pay frequency, and then I did the calculation based on 12 months, and I did the similar thing with the 52 weeks, and I compared the differences in rates. And there's just a little snippet of one of those scenarios. And I did a number of these, and obviously I put 0 paid weeks and so on in. And the thing is, because we're doing this over such a long period of time, even though there is perhaps very big differences here, so we got the monthly approach and we got the strict base weekly approach, when you actually average it over 52 weeks, the differences in rate can be quite small. So we're not necessarily saying massive amounts difference here, but again, there's always going to be outliers. And one of the options you could look at if you are truly back against the wall and there's no way to break out the weeks is basically to say, can I add an additional payment into the pot, which is always going to guarantee the worker will be better off than the base approach? So, perhaps an extra £100 or something. And if you can prove the worker's always better off, and you can, again, get that guarantee in terms of the legal guidance, you may be able to use that as an alternative approach. So we still do the 12 months, add in that additional, pushes the worker slightly above what the base expected rate would be. Because the worker's better off, okay, we know we're not necessarily strict on the guidance, but we are ensuring nobody is worse off. I don't know where that would fly. Like I say, I'm just purely providing options here, which may be food for thought. And again, may actually bring out other ideas as well in terms of as you start to tackle this. So if you have no support within your payroll solution, there are still potential options available to you. Again, if you have that Excel experience within your company internally, you can look at potentially building out something using that kind of tooling. There's also a growing number of automation software solutions out there in the market, and again, those kind of tools can do that heavy lifting around the calculations for you, and potentially reduce some of the risk, some of the manual labour around that as well. Ultimately, though, you need to do a consistent approach across your workforce. So if you do need to undertake alternative approaches, as I said, be sure to seek the correct legal guidance to validate those. Another option here would be to engage ACAS to talk through the resources you have available to you and what you're considering, because they can certainly give you their view and possibly additional steer and additional guidance that may reassure what you're doing is fine. What BAYS have suggested, although there's nothing in writing when we have spoken to them, is if you are showing close alignment to the guidance as possible, even if you're not hitting all the requirements, you should be in a good position to argue your case if for any reason this was to go to, say, to a court, or if BEIS, and I don't know how BEIS are intending to enforce this, were looking at what you're doing. The main point is doing nothing puts you in a much, doing something puts you in a much better position than doing nothing. As I mentioned, I'm not a legal expert. I'm not an employment expert. I'm just here talking through the guidance in terms of my own experience. And again, as we deal with it with our own customers at Workday also. Today's session is about opening up the guidance really and showing you the potential challenges. I'm purely here to highlight that. It's very possible your payroll system software might not currently support this guidance in its purest form, but please bear in mind the guidance is not clear in places and still needs clarification. Very much if you push BEIS in those areas, they will turn around and tell you to go seek legal clarification around that. And that's the final bit. I'm going to sign off there. So the guidance does not provide definitive answers to individual queries, and in some places takes views on matters which are uncertain. It is not intended to be relied upon in any specific context or as a substitute for seeking advice, legal or otherwise, on specific circumstances, as each case may be different. And that's BEIS's, I suppose if you like, almost like safe harbor statement. So just bear that in mind as well. They aren't going to try and cover off every scenario, and they will not always give you an answer on every scenario. And there's some contact there for ACAS again. So recommendation there is, that is definitely a resource you can reach out to and engage with. So we are going to do some questions and answers now, but I think we're going to do a quick poll if Mel's able to pop that up, please.
Yeah, we've got 3 different polls. So do you want me to start off with the do you feel the holiday pay guidance? Yeah, would that be the best one for you? Okay, cool. Okay, so our first poll is do you feel the holiday pay guidance is a good fit into standard payroll best practice? So I have launched that. If you guys can, we'll do this for a couple of seconds. We've actually got 3 quick polls.
And it is really good if you can reply to this, because what I want to use this information for is to go back to BEIS and to see if there is, in terms of the industry, what is the general pulse out there.
Okay, so we've had 60% vote so far. So if we can get up to 75%, that'd be fantastic. We'll be answering some of the questions as well after this. Okay, there's a couple more people, if they can vote. What do you think is going to be on this one, Danny? What's your gut say? Or shall I not ask?
No, don't. I might be proved wrong.
Okay, all right. So I'm gonna close this poll. So thanks for everyone that answered that. Okay, I'll share the results. Okay, so we have yes 31%, no 39%, and 30% of you feel like you need some more information to make an informed judgment on this.
Cool.
Okay, can you hear that okay, Danny?
Yeah.
Yeah, okay. Was that what you expected?
No.
Okay. All right, so let's go on to the next one. Okay. Do you feel your current payroll solution can handle all aspects of holiday pay? Okay, so we've got yes, no, need further information to make an informed judgment. So everyone's nice and quick off this one. So we'll just wait for a couple of seconds and then we'll go on to the final poll. So as Danny said, this will help your case really, won't it?
Yeah.
Okay, right, I'm going to close the poll in a couple of seconds. I think everyone's answered. Okay, so we have 21% yes, 61% no, and 18% need further information.
That's what I was expecting.
It was what you were expecting. Okay, yeah. I was obviously nervous to ask you.
On the nose.
Okay, nice. Okay, right, and then obviously the final one. So thank you everyone for getting involved in this. Okay, right. Do you feel the holiday pay guidance is the right solution for tackling this requirement? Okay, as I said, this is the last poll question. Do you want to say what your gut feeling is on this one, Danny, or?
I'm hoping the nose.
Okay. Okay, just a few more people if they can answer. We'll try and get it to 75% of you. That'd be fabulous. That's a nice round amount of people, I think. There you go. Thank you very much for the last person that just voted. Oh, we've got a couple more just coming through. Okay, I'm going to close it in a couple of seconds. Okay, right, I'm going to launch this. Danny, I think you're correct there. So there you go. Okay, so we've got yes, 30%, no, 50%, and 21% still feel they need further information. So, I mean, there's quite a common thing there. You know, people still need to know a lot more about this subject, and yeah, and no there. What do you think, Danny, on that?
Yeah, I think that's fair. I think the don't knows is interesting because again, it shows you perhaps there isn't a clarity there that we would hope with this.
Okay, right, I'm going to hide that. So we're just going to go on to some of the questions. Whilst you were talking, we were getting so many questions coming through. To be honest, I think this is going to be one that we will have to answer post-webinar, Danny, if that's okay.
Sure.
But I'll go through a couple of these now. Do I have to pay holiday pay for all of a worker's holiday entitlement?
Well, I say yes. So in terms of your obligation, it's the first 20 days. After those first 20 days, you don't have to pay holiday pay for that. Again, the tipping point is it then opens up more management if you've got workers changing their entitlement on a regular basis, because you need to make sure they're not losing out if they're dropping from full-time to part-time, that kind of thing. But yeah, 20 days is the requirement. In terms of our experience, what we see, most customers do the lot because it's simple, easy, but obviously there is the risk of additional cost in doing so.
Okay, this is one of the questions that we've had through. This person, sorry, I'm still slightly confused. Can I just ask if employees are on a fixed monthly salary but may get overtime for on-call at weekends twice a month, this calculation still has to be done? Obviously, does this calculation still have to be done?
Yeah, that's where you'd need to get clarification. My view, and it is only my view, that to me, if that's something which they're taking as being part of their contract, their regular salary, that would come under holiday pay. But that's where I would definitely recommend seeking that employment legal advice, from your own internal legal team at the very least.
Okay, if you have a salaried worker with fixed hours and salary, do we still need to do the holiday calculation because they've earned commission on top of their salary?
Yes, potentially you do. So commission was one of the original ones on this that brought the legal case. So these people, they were earning commission because that was part of their job, and that was deemed part of their package. When they were on holiday, they couldn't earn their commission, they were worse off, so they didn't want to take holiday. And that was one of the big reasons behind this. Again, what I would say is, it does to a degree depend on the type of commission, because it may be if they're perhaps, very big corporate deals, and regardless if they take holiday or not, the deal comes through, that may be a very different circumstance. So if they're on holiday and they can't get to their commission, then that's probably the tipping point. But as I said before, make sure you clarify with your own legal teams.
Okay, and somebody's asked, this is obviously whilst you're running your presentation, what if one of those weeks is holiday pay, you do not include?
So again, I did touch on that. It might have been before I got to it. So yeah, if it depends on the type of worker. So for certain types of workers, yeah, you do not include holiday pay at all. So that might mean you exclude a whole week's, or you exclude only a part week because there's a couple of days there, but you include what they were working that week. So if they took one day's holiday, the other 4 days would still be in, and the week wouldn't be excluded. However, for those other set of workers there, you would include holiday pay in the count back.
Okay, so if this is a similar question, okay, but do we have to pay holiday pay based on actual earnings, i.e. commissions, for unused but accrued holiday when the employee leaves?
Yes. If the guidance applies on a normal holiday pay calculation, sorry, normal holiday, it will apply when they leave as well, and redundancy.
Okay. Is it safe to say that the calculation of the holiday pay would be the payroll provider's responsibility? Last time we checked with our payroll provider, they refused to calculate it, as this is not a legislation, just an advice.
Yeah, it's a real tricky one. Obviously, as a payroll provider,
Sorry, Danny.
you can probably imagine what I'm going to say. Unfortunately, it's what I call it's not full-on compliance like national insurance. This drifts over into other areas like employment law. So and again, as you can see, the guidance itself is very woolly. That makes it very hard. It's not like we can pick up a statutory maternity book and just write that. It's very unclear. So that means it's a big change to try and put something in place around this. Yeah, so unfortunately, you can't argue probably that with your software vendor. You can try, but yeah, it's difficult.
Okay, right. Is there a maximum number of periods I can skip?
Technically, no. Well, technically it'd be 103 or 104. So 104 is the maximum. So if there's 103 dud weeks in there and you're only picking up one, so be it. Yeah, so 104 is absolute max time you could skip backwards, and if all 104 are empty, there's a question mark as to why the person's hanging around anyway. Yeah, so there's nothing like that.
Okay, can we calculate on an annual basis, meaning can we take total hours for 52 weeks divided by total earnings to get the average rate of pay?
That's an interesting question. With the payment rates, they provide some views, and I think you probably would be okay in that instance. And what you'd probably want to do is just do some validation calcs, running with what Bayes propose and what you're looking at, and then just seeing if there's any difference. I think the maths will stack up, and it would probably be probably the same. The point is obviously to remember that you still have to skip any 0 weeks. So just in case you were thinking, oh, I can grab 12 months worth, that's where you could run into issues. But yeah, if you can get the valid 52 weeks out of 104, I think you would probably be in a good position. But as I mentioned at the start there, just be sure to run some baselines calcs to check.
Okay, can you pay holiday pay every month rather than when the employee actually takes the holiday?
Unfortunately, no. It has to be based on holiday. And again, what they look at when you do every month, it's back into that kind of rolled up type scenarios where you're giving them a sort of an enhancement. And it may be that even that enhancement, they're better off than paying it when they go on holiday. But Bayes would take a dim view, and I think ACAS would as well, because their general feeling would be you're probably gaming the system, unfortunately.
Okay, this one slightly different. For an employee who falls ill during his holiday while for an employee who falls ill during his holiday, the employee has a doctor's note which will end at the last day of the notice period. Can these day of sickness be put back into the annual leave balance and paid out to him with his final salary? Sorry, this is somebody on garden leave.
I would
Does
need to
that make
check.
sense, that
Sorry,
question?
it does
Yeah.
make sense, yeah, but I don't have that knowledge to hand. Sorry, I'll come back to that one. I'm happy to go and have a dig.
Yeah, a post one.
Yeah.
Okay. Let me just have a look for you answered that one nice and quickly, so you've put me out there.
Sorry.
But no, it's all right, don't worry. Okay, does continuous service date impact the reference period?
Yes and no. So yeah, if the TUPE work, if it's a TUPE worker and they've got a continuous service date, then you still need to count back into that into the past. If it's continuous service date, say like a teacher, for example, but they're not, when teachers start, they get continuous service date as they move between schools. However, they're not TUPEing, so there's going to be no history they're going to bring with them. So in that instance, you would only go as far as the new hire. It's ultimately the TUPE which can determines. Does that make sense? Sorry.
Yeah, it does. Thank you, Danny. Right, we'll just do the last question. So as I said, there are so many questions, so we will come back to you post webinar. Also, if you want the slides, you should be able to download slides on the handouts, which should be on your panel. Okay, so this is the last question. We pay every quarter. Is that acceptable based on 20 working days a year, so 5 days a quarter?
That sounds like they're talking about, I don't know, as John's answer, I'm not quite sure on if they're what's happening there. Sorry, I can't, not enough information. Sorry, if you can provide some more details, I'm happy to answer.
Okay, so the person that's written that question, if you want to email myself, melanie@globalpayrolassociation.com, which you should have anyway when you registered for this webinar, and then we can see if we can answer that for you post webinar. So I think we'll come to an end. I think we've got like a minute left. Danny and I have spoken, well, previously before we started today's webinar, to say that we will be looking to run further webinars, maybe on holiday pay. Danny did mention at the beginning that should we, should you want us to cover anything, please let us know. So you're happy to do that? Is that correct, Danny? I hope that is correct.
Yeah, that's correct. Yeah, more than happy.
Excellent. Okay, so so thank you very much, Danny. We hope to see you shortly on another webinar. And as I said, if you've got any questions, then please let us know. But thanks once again, Danny, and I hope you all enjoyed today's session.
Thank you all.